Awesome. Keep the businesses coming. As we go through the presentation, drop your business name, what you do, into the chat so we could tailor the presentation for you. It is now 12:02, so we're going to go ahead and get started. Yeah, welcome to another NJ Drives Thursday, every Thursday at 12 p.m., a weekly webinar series for New Jersey small business owners. I'm your host, Christian Pichardo, NJSBDC marketing consultant and CEO at nilumomedia.com. So we're the America's NJSBDC. Basically, it's a statewide program powered by the SBA and state partners that help small businesses with no-cost small business consulting, training and events starting at $0, and exclusive small business resources. So for today's agenda, we're going to have a couple headlines. Some of them are reminders from last week, and we'll get into the webinar, and closer to the end, we'll hold a quick Q&A. So jumping right into the headlines. So this is a request by our wonderful Garden State government to please respond to the Federal Reserve Bank's 2021 Small Business Credit Survey. So as you know, any type of survey, even if it's from us, we send out surveys all the time. It's to help improve a service for you. So we urge everyone to complete this survey so that the Federal Reserve Bank knows how much support and resources to give small businesses. If they hear 0, then guess what you get. So it's very important to submit your feedback and what you'd like, basically. So that is the first one. The second one here is basically a reminder for it's a financial assistance program. This is specifically for, let's see, New Jersey-based companies that have already received federal SBIR and STTR grants. So you need to be an early stage company that is already engaged with these types of programs. The applications are due tomorrow. So that is there. By the way, we dropped these links into the chat, so you'll be able to revisit them later. For a third one, I don't know if anyone here knows, but our host institution for the state NJSBDC headquarters is Rutgers, and they are holding a Managing Uncertainty, Financing Workforce and Sustainability webinar. Well, it's a symposium. It's all online. It's free. The cool part about it is that Ray Chambers, he's a philanthropist and a humanitarian who currently serves at the World Health Organization. He's helped millions of people at this point. So, you know, do your research on him. If you Google his name, he'll pop up. But yeah, free symposium, October 28th. And the last one here, it comes from about 2 weeks now. We're still not exactly at October 20th, but good news on this Small Business Lease Grant Program applications. Again, they opened on the 20th, so I'm not going to open that link, but then we got an update that 10.2 million is going to be added to that program. So there's more funds available for the Small Business Lease Grant Program. And just as a reminder of where you should be submitting your information, let's see. I'll help you guys out. So it'll be this link here. I'll actually put it into the chat because I think this one is very great for small businesses right now. So put it on your calendar, October 20th. So there it is. I added it in the chat. And those are all of our headlines. So before we start the webinar, I'd like everyone to keep 3 things in mind. Please type in your questions into the Q&A box. When it's in the chat, some questions might get lost, and we do focus on the Q&A questions first. So submit them there. Number 2 is you're going to get redirected to a survey immediately after this webinar ends. So please fill that out. Once you fill it out, you'll get access to the recording and materials. And number 3 is by joining this event, you're eligible for the Upgrade Your Business certificate. For more information on that, go ahead to that link there. We drop all links into the chat. And now, without further ado, I'd like to welcome Michelle Schaap to this webinar where you're going to learn what small businesses should know about cyber and privacy laws. And this is the first part of a Protect Your Tech series. So for those that don't know, October is Cybersecurity Awareness Month. So the entire month we talk about cybersecurity and how to keep your business safe online. So yeah, welcome, Michelle. Thank you for coming.
Thank you so much. And I think I need you to stop sharing so I can start sharing. Aha, there we go.
There you go.
So let's see. Technology is such a wonderful thing when it works. And of course, when it doesn't work, then we have potential disasters. But today's program is going to be focusing on cybersecurity and privacy laws, which anticipate in some cases things that could go bump in the night, and in some cases tell you what happens when the oh my God does occur. We're also going to discuss what you've committed to contractually, regardless of what your legal requirements, or should I say by law requirements are. So what you've agreed to regardless of what the law requires, as well as how some of those contractual terms could come back to bite you and how you might better negotiate some of those terms, notwithstanding that you guys are indeed small businesses and may or may not have negotiating power. But with that, let's jump into this. And as Chris suggested, please do not hesitate to interrupt me with questions. So if you see something on a slide, or if I say something, you say, well, wait a minute, what about this? Please feel free to jump in. If I get thrown off, it's okay, we'll come back. I'd rather address your concerns and make sure you're getting out of this what you need. So, as Chris knows, no legal presentation is complete without a legal disclaimer. So here's my legal disclaimer. If you would like to speak to me directly and receive counseling, you can do so through the SBDC. Feel free to contact them, but this is general information. So with that, let's talk about the legal landscape. And you should understand, and you probably have heard about the California Consumer Privacy Act. At this point, you may have heard about the New York Shield Act. You may have heard about the New York State Division of Financial Services regulations. I'm sure you're familiar with HIPAA just by going to the doctor and signing your forms that say, yes, you can tell everybody and your kid brother about my personal health information and so on and so forth. New Jersey has yet to pass a proactive piece of privacy legislation. They've had stops and starts. They haven't done it yet. But regardless of what New Jersey has in place, there are other legal frameworks and other legislation you should and need to be aware of. So let's start with the FTC. Article 5 of the FTC Act says that you are violating that act if you misrepresent what you're doing. So for those of you who've heard me speak before, you know that one of my favorite stories is a client of mine who had asked me to help them update their website for their not-for-profit organization. So I thought, well, maybe they had played with the privacy policy on the for-profit entity, and that's where the privacy policy came from that was on the not-for-profit site. So I log in, I go to the website for the for-profit entity, click on the privacy policy link, and right at the top in big bold letters, it says, we guarantee your privacy. Well, we all know from the headlines that we see almost daily, and certainly on my news feed every hour, nobody can guarantee privacy at this point. That statement alone would be a violation of the FTC Act. And even though New Jersey doesn't have a proactive piece of legislation that says that you can't do certain things, it does have legislation with regard to unfair or deceptive trade practices. And what some states call them are little or baby FTC acts. So that's part of federal law, the FTC, and the state of New Jersey has an equivalent. Now, I know at least one of our attendees is an advisor to healthcare and dental practices. So I am sure he is very familiar with HIPAA. And for those of you that are not physicians or healthcare providers or a covered person under HIPAA, you may nevertheless be a business associate of one of those covered entities. And as a business associate, it used to be that you didn't have direct liability under HIPAA, but the law was changed. And now as a business associate, meaning somebody who helps with billing and sees patient information, you are directly responsible to comply with HIPAA and its security and privacy rules. And if you don't, that's a reportable obligation and a violation of HIPAA. That comes with fines. It comes with the regulators getting into your shorts. These are bad things. Now, what's nice about HIPAA is that it is a proactive piece of legislation, and it defines what, in fact, those who are subject to HIPAA have to do. Now, my guess is none of you are dealing with Gramm-Leach-Bliley, given what I saw in the chat. However, to the extent that you might be a service provider or a vendor to an organization that is subject to Gramm-Leach-Bliley, they have probably knocked on your doors already. And if not, they are likely to do so to say, we're entrusting you with our customers' data as our service provider. Well, what are you doing with it? And they want to know the answer to that. And you need to be able to answer that question and to answer it honestly and responsibly. Now, a lot of my clients say to me, what am I worrying about the General Data Protection Regulation, GDPR? And in fact, I got a call a couple of years ago from a theater in Montclair. And I happen to know the theater. I've been going there since I was a kid. One location. They were redoing their website, and their web designer said to them, well, you need a new privacy policy. Oh, and by the way, it needs to be compliant with GDPR. So the client calls me, tells me we need a new privacy policy and we need to deal with GDPR. And I said to the client as politely as I could, why? And he said, well, because my web designer told me so. Well, I know the theater. One location. They may be advertised in the Star Ledger, maybe in a few other magazines or online or what have you. But as I said to the client, well, let me ask you this. If I'm coming from the UK to the United States and I'm flipping through the British Airways magazine of things to do when I land in the United States, is your theater advertised there? And he said, no. I said, okay, do you market at all to people in the EU or the UK? And he said, no. I said, do you collect payment in euros or in pounds? No. And we go down the list. And I said, okay, let's worry about the United States privacy laws. When you start to get clientele from the UK on a regular basis or the EU, when you start advertising that, we can talk about it. But think about this, as I'm being so flip and saying, don't worry about GDPR. You may, in fact, be receiving information from parties with whom you do business. Now, it doesn't apply necessarily to information that you're collecting here in the United States, and it doesn't apply to somebody who's an expat who's working here in the United States, even though they're an EU citizen or a UK citizen. However, if you're involved in a transaction with an international entity, they may send you a data protection or a data processing agreement because they're required to do so under GDPR. And by the way, you'll gather there's a theme here when we're talking about out of New Jersey legislation. And that is that it's more likely than not that you would be pulled into those requirements of those different laws, not because you're directly subject to it, but because you may have customers who are subject to it. And by those laws, your customers are being required to vet their vendors that are going to be processing their information. And so if the customer has to check the box, you're one of those boxes that has to be kicked around, looked into, and said, yep, I can work with this vendor, I can entrust my data to them. So even if you're not subject to some of these laws or laws that may be adopted in the future, because you have clients who are, they're going to want to know, are you acting reasonably? Now, in addition to worrying about these laws and other laws that may be coming down the pike, if any of you are vendors to defense contractors, I'm sure you've already had them climb into your shorts because they absolutely have to vet their vendors. And if you have software products or services that you are selling to the US government and even civilian agencies, by Biden's executive order of May 12th, there are going to be new requirements if you want to continue to be a provider of those services to the federal government and agencies, including being transparent as to your technology, reporting if, God forbid, you have a breach, and various other things. Now, you also need to think about what you have agreed to by contract, which we're going to get into further in this conversation. But keep in mind that already you probably have signed contracts that require you to keep information confidential. A lot of people don't equate confidentiality agreements and non-disclosure agreements with cyber breaches. But to me, the logical question is, why not? If there's been a breach of your environment, even if it's been hacked and you didn't do something, you've still allowed that information to get out. And then the devil will be in the details of what that contract says as to whether you have liability. I've also mentioned on the slide breach notification laws. 50 different states have 50 different breach notification laws. And if you have customers in multiple jurisdictions or employees in multiple jurisdictions, that's something you need to be aware of. And before we move on, I want to mention the New York Shield Act, because again, given the proximity we are to New York, the odds are good that you may very well have customers or employees who are residents of New York. And you have an obligation under the New York Shield Act to take reasonable measures to protect that information and to keep it secure. So again, even though New Jersey doesn't have a proactive piece of law like New York or California or Virginia or Colorado, it's something that you need to be cognizant of. Now, we've already talked about this. I also want to mention states like Massachusetts. And Massachusetts has had a law in the books for several years now. And Massachusetts law requires that if you are holding information of Massachusetts residents, you not only have to take reasonable measures, but you have to have a written information security program. So if, God forbid, something happened and Massachusetts reached cross borders to us here in New Jersey and said, well, it's nice that you had this information, how are you protecting it? That's something you need to be able to answer. And again, before we leave California, and this is the state, the gift that keeps on giving, just to understand what and how they define a service provider and what is required. So if, let's suppose I am a California-based business and I'm subject to the California Consumer Privacy Act, and you're providing services to me, I have to have a written agreement with you as my service provider that says not only are you using reasonable measures, but you're going to continue to do so. So it's not just that you have customers that may be kicking your tires. They may be requiring you to sign contracts in that regard, not just because they're paranoid and they want to pass down liability, but they're required by law to do so. There's also a common law duty that's been recognized by our neighboring state of Pennsylvania. And you say, well, why do I care about Pennsylvania? We're here in New Jersey. Well, again, first of all, you may have employees or customers from Pennsylvania. But second of all, I will tell you that other courts outside of Pennsylvania have cited to this decision. And what's important to know about this Dittman case, and again, for those of you who've heard me speak, you've heard me mention this case previously, the scam is a known scam. It's something that was shared by the IRS back in 2015. Then it was shared by the Society of Human Resources Professionals in 2016. So now come 2017 or 2018, when this particular breach occurred, the plaintiffs in the case said, hey, employer, you should have known that there are scams out there trying to steal employees' W-2s. This is not a news flash. And you didn't do the basic things to train personnel to understand that if you get an email at 4:45 on Friday saying we're having a Department of Labor audit on Monday, send me all the W-2s, that before you run out to happy hour, you at least pick up the phone and ask your boss, is this for real? Because the company didn't take those basic reasonable measures, the court found that the company had failed to exercise a reasonable duty of care for a foreseeable risk. In other words, in the state of New Jersey, and I think they would be likely to follow this line of reasoning were to be put before a court, you can't say you didn't know there were hackers out there. You can't say you didn't know that there were phishing attacks happening. And if you didn't bother to educate yourself and didn't bother to educate your personnel, at a minimum, to pick up the phone, then you haven't met that simplest duty of care. And by the way, some jurisdictions have taken the Dittman theory further and said that because a company didn't take those basic measures, reasonable care, that the company was in effect complicit in the breach that allowed for all the W-2s to be released. And when you get to that type of language in a court decision, then you're potentially talking about things like treble damages and punitive damages, things that a small business owner never wants to have to worry about. Now, as far as New Jersey's breach notification law, depending upon whether or not your data has been encrypted or not, and whether or not the bad actors also got the decryption key, will decide whether or not you have a breach notice obligation. If in fact your information is encrypted and all the bad actors got was gobbledygook, then guess what? You don't have a reportable breach, at least not to the state of New Jersey. Doesn't mean you don't have reporting obligations under potential contracts that you have signed, but at least you're not reporting to New Jersey State Police. The other thing to keep in mind with New Jersey is that depending upon how many people were involved in the compromise, not only do you have to report to the state, but you may actually have to publish notice. And just what you want to be, a headline on the Star Ledger. So think about the ramifications if you have to give this type of notice. And I am going to scooch over. Yes.
Just super quickly, I have a question that I think is relevant for right now that came in. It says, okay, just for clarification, if we have clients in other states, we also have to abide by each state's cybersecurity laws.
Well, I'm going to sound like a lawyer and say it depends. And again, as small business owners, I'm sure you're scratching your head and saying, how am I possibly supposed to know what other states require? And bear with me, I'm hoping that my backward key will work. If it doesn't, I'll ask you to look at the slide deck when you get it, but let's see if this works for us. Look at that, it's working. So right here on this slide, these are resources that you can click on that are updated regularly that will show you what states have adopted privacy legislation. Now, I know that you're thinking to yourself, oh my God, you've got to be kidding. I'm a small business owner and I'm supposed to keep track of laws in New Jersey and New York and Pennsylvania and Connecticut and Delaware and. And those jurisdictions that have adopted proactive legislation would say with a straight face, yeah, if you want our citizens and our residents' information, then you should be protecting it. I'm sure that some of you are already getting nauseous by that statement, and I apologize. And in fact, coincidentally, I actually just had an article published yesterday that talked about the patchwork of privacy laws in the United States and advocating for a federal piece of legislation that would supersede this patchwork quilt of California and Virginia and Colorado and so that large and small business owners don't have to ask that question and don't have to say, what state's laws do I need to be worried about? But let me give you a specific concrete example, which the short answer is yes, you need to know about these different states' laws. So first of all, if you have employees in New York, then yes, you are subject to the New York Shield Act, and you have to take appropriate measures to protect those employees' personal information. If you have customers in New York, you need to be taking certain measures to protect that information. If you have customers in Massachusetts, if you have somebody who applied for a job with you, even if you didn't hire them, if you're retaining that information and you did a background check on them, how are you securing that information? Now, I had a client contact me a couple of years ago, and Chris has heard me say this before. My geography of the United States is somewhat challenged, so bear with me. The client was located in one of those square states in the Midwest, and those square states are surrounded by several other states. And this company was large enough that it had employees not only in its home state, but in the states that bordered against it. and they had a data breach similar to what was experienced in the Dittman case. And they said, okay, so what do we have to do in terms of breach notification? And I said, well, we need to look at each state's breach notification laws to see to whom you have to report and how you have to report it. It'd be really nice if there were one-stop shopping, if you could just report to one location. I had a breach, it really sucked, here's the information. But that's not how it works. So one of my clients, and again, some of you have heard me speak about this poor CPA firm that was compromised. Their customers that were impacted were primarily in New Jersey, but they also had customers in New York and they had customers in Delaware, all of whom were impacted by this breach. And we had to make sure that when notice was given, not only to law enforcement, but to the impacted individuals, notice was given in compliance with each state's requirements. And I will tell you, New York has its own very specific forms they want you to use when you are reporting a data breach. Shockingly, so does California. New Jersey hasn't gone that far yet, but they do say what they want you to share with your customers. And by the way, once you share information with your customers, needless to say, they're going to have follow-up questions. And you need to be careful as to what you share with them and what you don't, because now you're getting into reputational compounded risk. Because not only did you now have a breach, but if you're not giving complete information or misinformation to your customers in the breach notification, they're really going to be twice unhappy with you. And before you can tell your customers, you also have to notify law enforcement. And by the way, the FBI, contrary to what a lot of people will tell you, they're not out to get you when it comes to a data breach. Their goal in hearing from you with regard to a data breach, and the same thing with the state cyber unit, is not to say gotcha. Their goal is to help you and other small businesses. So let's suppose that I'm hit by a certain type of scam and I report it to New Jersey State Police. And now the New Jersey Cyber Unit pushes out to New Jersey businesses information in their weekly, and in fact, today is the day, Thursdays, when they push out their weekly notices to New Jersey businesses. And they say, be aware of this scam that has been seen by business owners in the state of New Jersey. If I didn't share the information of the kind of attack that I was facing, you all wouldn't find out about it until it happened to you too. The other reason why it's important to notify law enforcement is, God forbid you get hit by ransomware. I will tell you that the FBI and the New Jersey State Cyber Unit have the decryption keys for at least half of the known flavors of ransomware that are out there. So if you were hit by ransomware, there's a possibility that you could then at least have the business decision to make, do I want to pay the ransom or not, if I could get the decryption key from the FBI. Now, you may still choose to pay the ransom because unfortunately what ransomware attackers are doing these days is several prong attack. So first of all, what they'll do obviously is demand ransom so that you pay them money and they give you the decryption key. But they might also say, oh, and by the way, we're going to be notifying your customers that you were compromised, unless, of course, you want to pay us to stop us from doing that as well. Or they may contact the customers and say, by the way, I've got this information. Your vendor didn't keep it secure, your service provider, and I'm going to put it out there unless you, the customer, pay me. So it becomes a multi-pronged source of revenue for the bad actors. Chris, you going to quit your day job yet? Hopefully not.
Not yet, not yet.
So hopefully that answers the question, but please feel free to let me know if it did not, and we will go back to it. Now, I'd mentioned again, 50 different states have breach notification obligations, so we're not going to belabor that point. The other thing I want to do is just look at a few other statutes in the state of New Jersey. I'm not going to belabor them, but if these statutes pertain to you, just to be aware of them. So for example, if you recall, and I'm old enough to recall this, it used to be that you went to a store and you would pay either by credit card or check or what have you, that you would have to show certain forms of identification. And in fact, if you were paying by check, they would write on the back of the check information about you. So if, God forbid, your check bounced, they could come after your credit card or something else. They can't do that anymore, which they being the retail establishment. So it's nice to know they can't do that anymore. However, they do have the right to verify, for example, your age, if they're selling you alcohol or cigarettes. But that doesn't mean necessarily that they are repurposing that for anything, including for marketing or advertising activity. So if you are allowed by this statute to collect this information, understand, number one, what you can and cannot do with it and why you can ask for it. Number two, as it says here, that you must securely store that information. Whoops, I didn't mean to emphasize by changing our slide. And you cannot use it for other activities. And of course, keep in mind that these result in civil penalties. And each offense means each violation. So if you collect Chris's information and my information and each one of those has their own penalty associated with it. Keep that in mind. Oops, now we're going the wrong direction. Here we go. Now, the next statute I want you to be aware of is the New Jersey Wiretapping and Electronic Surveillance Control Act. And the reason why this is important for you folks to be aware of is that you've got employees who are obviously using systems. You want to make sure that they're using them only for business-related matters. So in the state of New Jersey, you can put into your employee manual that says you should and understand you have no expectation of privacy when it comes to your use of company issued devices, when it comes to use of company email, company resources, and so on and so forth. So you can, in fact, I won't say spy on your personnel, but at least monitor their use of company resources. The other thing to be aware of is, when you talk about you're dealing with either a disgruntled employee or whether you're making a call to investigate something and you want to know, can I record that conversation? And New Jersey is what we call a one-party state. So let's suppose that Chris and I are here in New Jersey and Chris has done me wrong. Sorry, Chris, I'm throwing you under the bus.
Oh, no.
And I want to call him and I want to record him admitting, yeah, you're right, I sold you a bill of goods. I can record that without telling Chris because I am aware that it's being recorded. If we were located in a two-party state, I couldn't do that without telling Chris, oh, by the way, I'm recording you. Which is why, by the way, oftentimes what you'll hear when you call up, for example, a bank or something else, and you hear online, this call may be recorded for quality service. Well, it may be recorded for quality service, but it's also probably being recorded, and they need to tell you by law that it's being recorded. The other thing to keep in mind is that, again, sorry, Chris, you're the face I'm seeing. You are doing all sorts of bad things today. Chris is now getting fired. And I want to look at his email to see what he has done wrong using the company systems. However, the fact is that Chris is, I'm making you the good guy now, Chris is a whistleblower. I've been doing bad things. And he's been using company systems to send information to his attorney in his whistleblowing suit. Well, under certain circumstances, even though I can look at what he's doing on company systems with company resources, I can't read his correspondence with his personal attorneys. So if you're looking at your employees' emails on company devices or what have you, be mindful of what you can and cannot do in that regard.
Michelle, that sounds very similar to what happened just earlier this week for the reason why Facebook, Instagram, and WhatsApp were shut down. The whistleblower copied a bunch of company documents, and I forget who she handed it over to, but
Congress.
Right. So employees could take your private company files at will. Is that possible in New Jersey?
Well, when you say at will, there are certain things that employees can and can't do. So think about Facebook is a perfect example. And Facebook had all sorts of information. And for anybody who has a daughter and possibly a son as well, and I'm biased because I have a daughter and I've seen what is on Facebook and I've seen what is on Instagram, what have you. And the stuff that's out there is toxic. And we've all read the horrible news articles about girls committing suicide who've been encouraged to commit suicide through social media. Facebook had this information. And they buried it deep inside the bowels of the company's systems. And this woman released it. She's a whistleblower. And there are whistleblower statutes will protect employees from being prosecuted by their employers for sharing this information. But other than that, other than certain circumstances, employees, so long as you are advised in the company's employee manual, are advised you have no expectation of privacy. And again, one of the things, and we'll obviously digressing here a little bit, but you want to have all of your employees sign non-disclosure agreements, or at a minimum, having your employee handbooks, having your employees agreeing not only to confidentiality, that is keeping your secret sauce confidential, but also making sure that they are not going to remove any information. And in fact, there is a statute on the books, a federal statute, the Computer Fraud and Abuse Act, which says that you cannot access systems for unauthorized purposes. And I'm simplifying this, but let me also caution you that a recent Supreme Court decision narrowed the interpretation of that statute. And so the scenario was, and I may be getting in fact slightly off, but went somewhere along the lines of this. A police officer was entitled to access the systems of the local police department. It was his job. However, he accessed it to get the license plate of a woman having nothing to do with law enforcement. Needless to say, abuse of his access credentials seems kind of like a no-brainer, except for the fact that the way the Supreme Court interpreted the Computer Fraud and Abuse Act is they said that he was authorized to access that system. And because he was authorized to access the system, even though he used it for an unauthorized or not job-related purpose, that was not considered, based on this recent ruling, as a violation of the Computer Fraud and Abuse Act. I will tell you, and I haven't addressed it here in this slide because I was really more focusing on company obligations and employer obligations rather than employee obligations. New Jersey does have its own statutes that more specifically speak to that, and more narrowly, or should I say more broadly, looks at the computer fraud potential there. And in fact, I will tell you, one of my clients several years ago had an employee who was being terminated, and she was being terminated remotely because she was on disability. In the middle of the exit interview, remember, it was done similar to this, they were watching files being deleted from the company accounts. The woman's access credentials had not been disabled before they had the exit interview, and she was stealing company files. And I will tell you, that was absolutely a violation of New Jersey legislation, regardless of what the Computer Fraud and Abuse Act would require and how the Supreme Court recently interpreted it. But again, that goes back to the importance of you having well-written confidentiality agreements with your employees. Good?
Wow. Yeah.
Cool. In terms of New Jersey identity theft prevention, again, and I don't know if you guys remember this, and I certainly remember this, that you used to get letters, whether it's from an insurance company or from your school or what have you, and they would use your social security number as your identification number. And it would be in that little glass envelope in the mailer that you got. So the postman could see Michelle Shep. Oh, and her social security number, it's right here. Thank you so much. Well, you can't do that anymore. You cannot use social security number as an identifier that's going to be seen in that fashion. Keep that in mind if you are collecting social security numbers. Now, granted, that's not to say you can't do background checks on your personnel. If you're extending credit, you can use it for certain information. But again, if you have that information, remember you do have an obligation to keep that information secure. And as I mentioned, as an employer, you can use it and you can retain records for a period of time. And in fact, by law, you are required to retain employee records for a period of time. However, if you need, so let's suppose Chris hires me. Chris, I'm now going to be the one who's under the bus. Correct. And I screw up and Chris needs to fire me. Well, by law, Chris still has to keep information about me as a former employer for a period of time. However, if Chris is smart and he's got my name, he's got my address, he's got my social security number, let's suppose my dependents were on my health benefits, so he probably has my husband's name, he might have kids' names, information, what have you. If you need to save that information, don't keep it online. That's simple. Keep it securely and keep it offline. Keep it in paper files or keep it in a separate HR silo on your systems that is restricted by extra authentication. So let's suppose that I'm logging into the company systems because Chris rehired me, and I log in, Michelle Schapp, and I have my password and I have my multi-factor authentication. So I've gotten my text message with the code I have to enter. But if I'm not part of HR, I shouldn't then be able to access the HR records. There should be yet another layer of access, and the password or the passcode to get into those accounts shouldn't be admin1, admin2. It should be, again, another series of robust access credentials. So keep that in mind, because you do have information. If you're an employer, it still has to be kept securely. Keep things offline if you don't need to have it online. Now, while we are talking about the topic of data destruction, you have an obligation to securely destroy customer records under the laws of the state of New Jersey. And I believe it was ShopRite that recently, in fact, earlier this year, was throwing out old equipment, including scanning devices and what have you. So when you check out at ShopRite and you throw in your credit card into the scanning device and what have you, they threw it out into the dumpster. Didn't bother to wipe the data. I assure you that is not a secure means of destroying those records. And I will tell you, just the other day, I went over to my office with a ton of papers to be shredded because I am a paper pack rat. And when I work, especially at home, I want to have paper. Well, everything that I do for my clients has to be kept confidential, regardless of whether it has personally identifiable information or protected health information. I can't just throw it out. So what I do is I bring it back to my office. My office has a company that comes to our office with their special handy dandy shred truck. And they don't drive away with the paper. They shred it right in our parking lot. So when you're getting rid of information, make sure it's done securely. And later on, you'll see at the end of our conversation, I talked about if you have leased equipment, making sure that that equipment and any data that's stored on it is appropriately removed and destroyed before you return that equipment off of lease or before you donate it to a charity, because they're not necessarily going to do that for you. Now, we've been talking a lot about the law. And Chris, before I shift gears and start talking about contracts, did we have any other questions or comments about the legal requirements?
Yeah, sure. Let me check in the Q&A. I do have a very specific question. So I'll go for it. Pam asks, I conduct market research for consumers and business employees in the US. I share results of survey results with my clients without name, email, IP, geographic address. I do collect race, ethnicity, zip code, age, gender, age bracket, gender, HH membership. What should my privacy statement include? My survey platform is GDPR compliant, and my analysis is conducted on Dropbox.
If you have in fact confirmed with a privacy professional that your practices are GDPR compliant, that gives me the warm and fuzzies. If in fact you're not 100% certain that you are GDPR compliant, we should have a conversation offline, because this is not a 5-minute answer. But I will tell you, I have a lot of clients that do exactly what you have described in some fashion or another. And keep in mind, there's a lot of things to consider. And I don't want to get too deep in the weeds on this issue, because this is a complex question with not a yes or no answer. First of all, it depends on where you're getting your list of people that you're surveying. So if you've purchased lists, then you need to know whether or not the people whose names are on those lists were properly collected in the first instance. And if they were in a jurisdiction where consent was required, was consent given? Because if it wasn't given and now you're using that information, you may have a problem just because of where you source the list. The other thing is, to the extent that you're picking up the phone and calling people and soliciting information, you can have other concerns about whether you're violating the TCPA Act by calling people at unsolicited numbers, that especially on personal numbers, if you're calling, God forbid, after the anointed hours under the TCPA. And by the way, not only do you have to worry about the federal law, but New Jersey has its own restrictions about what you can do vis-a-vis telemarketing and text marketing and so on. All of that said, if the information that you're giving your customers truly is anonymized and not able to be re-identified, you're probably okay, especially if you're saying that you're GDPR. But again, this is not a black and white answer. And I don't want to get too much into the weeds here, but I will tell you that there was a study that I read about a company, I believe it was in Oregon, that was doing study on a healthcare matter and how things were being addressed in hospitals, and it had to do with catastrophic accidents. Well, from the descriptions of the accidents and the injuries, and there was enough detail in the study, even though it didn't say the person's name, it didn't give social security number or anything else, that if you took that data and also compared it to local newspaper articles about accidents, you could actually re-identify the data that was supposedly in an anonymous study. So you need to also think about, how are your clients using the information that they are giving you? And are you restricting them in your contracts? And as far as what should be in your privacy policy, you want to be as transparent and clear as possible. This is what I'm collecting. It is anonymized. It is not re-anonymized. It is completely stripped out so that we cannot re-identify it with Michelle or Chris or somebody else. And you should be restricting your customers and their usage, that they don't pair that information with other information they may have collected to, again, themselves re-identify the person who responded to your survey. But please feel free to reach out to me offline. I don't want to get too deep into the weeds on this issue, and I'm more than happy to talk to you about this further. Any other questions before I move on this, Chris?
You let me know if this is relevant now, or you might answer it later. But it says, what are some laws to take note of regarding cyber liability insurance for small businesses?
Interesting question. And most of that for you guys is contractual. You may have contracts that say you're going to maintain cyber insurance. When you're having private transactions, so let's suppose that either Chris or I or our companies were to hire you as a vendor. There's no law in the state of New Jersey that says you have to have cyber insurance. And by the way, cyber insurance is harder and harder to get these days, particularly for a small business owner. However, if you wanted to bid on a government contract, if you wanted to bid on a state agency's contract as part of the RFP, you may not even be an eligible bidder without having cyber insurance. So it depends on the type of transaction that you're entering into. As a general proposition, there is not a piece of legislation per se that says that you have to have cyber insurance. So I hope that's helpful. Now, let's dig into the contracts, because I mentioned at the beginning of our conversation the concerns that are raised by confidentiality agreements. And besides how your customer defines confidential information, there's so much more to think about here. And by all means, I don't want to short shift the importance of understanding how your clients do define confidential information, because if in fact you're protecting something, you better know what it is that you're protecting. And I will tell you that when I'm drafting confidentiality agreements for my customers who would be engaging you guys as service providers, I will tell you that I define confidentiality information as extremely broad. Whether it's disclosed in writing, whether it's disclosed online, whether it's information that you produce in your analysis of the information that I've given you. On the flip side of that, you and your attorneys as small business owners may draft confidentiality agreements for you that try to put me back into a box and to narrow what is confidential information. And it may say that I actually have to identify in writing, this piece of paper is confidential. This information that I'm emailing to you is confidential. Or if I disclose it to you verbally, I have to confirm it was confidential in writing within 30 days. Putting back on my hat as the customer, I will tell you, I will strike that clause every single day from Sunday. It is a horrible clause if you're the one that is disclosing information, and it's a great clause if you're the one who's receiving the information, because then at least you know what you're supposed to be protecting. And then you can educate your personnel, and you can make sure that however you've crafted your internal non-disclosure agreements with your personnel and how you've crafted your agreements with subcontractors, that you're mirroring that language. Now, I will tell you that a lot of agreements, whether it's a confidentiality agreement, a master services agreement, a work order, what have you, you'll see that you are required to report a breach or a security incident. Again, you need to understand, what does that mean? And in fact, this is something that I negotiate regularly for my clients. The ones whose information has been entrusted to the service provider want to know about anything that could possibly compromise their information. Not that it did, but that it might. And so let's suppose that Chris and I were both your customers. If Chris's data was compromised, I want to know about it, because not only might my information have been compromised as well, you just don't know it yet. But now, going back to cyber insurance, let's suppose that you did get cyber insurance and you have $2 million in coverage. Well, if Chris already has a claim against you, how quickly is that $2 million going to get used up? And me as another customer, I might say, yeah, I'm not waiting to be the next breach, knowing that your insurance limits have already been eroded by Chris's claim, and I may terminate the contract right then and there. So you want to really understand not only what your reporting obligations are, but what the ramifications are. And if it's in fact a breach, what are the timing obligations? Because again, remember, you've got breach notification laws that say that if personally identifiable information or protected health information or sensitive information, and again, different states define that information differently, you have reporting obligations. But now you're talking about your customers, and their information may have nothing to do with personally identifiable information or protected health information. It may have to do with the launch of a new product. It may have to do with the launch with a new brand. And that's secret sauce for your customers. So you may not have any kind of a data report, a breach obligation under New Jersey's state law, but contractually, you now have an obligation to tell your customer. And if you have to tell your customer, you want to know, when do you have to tell them? Do you have to tell them in 5 minutes? Do you have to tell them in 24 hours, 3 business days? And have you now kept track of that? And I will tell you, and again, I digress a little bit, but in our firm's incident response plan, whenever our customers tell us, by the way, if you have a breach, we want you to tell us, I have a separate tab in our incident response plan that tracks all of our individual clients that specifically require to get notice from the firm if, God forbid, we had an issue. And I know who I'm supposed to contact in that chart. I know how I'm supposed to contact them, meaning, am I supposed to call them by phone? Am I supposed to send them an email? Am I supposed to do both? And I have the time frame that I have to give that notice within 24 hours. And by the way, that isn't kept online, because if, God forbid, I get hit by ransomware, I'm not going to be able to access that piece of my incident response plan to know that, oh my God, I was supposed to call Chris 2 days ago to let him know this happened. And now, not only have I had a breach, but I've breached my contractual obligation to Chris to boot, insult to injury. The other thing to watch out when you're dealing, especially with larger clients, oftentimes what they'll do is they'll have embedded links in their contracts. And so it'll say, you will comply with our policy found here, click on this link. Well, the problem is, first of all, did you click on the link to see what you signed up for? And second of all, if those are linked terms, the odds are good they also say that the customer can unilaterally change those, and you agree to be bound by them. So the contract that you think you signed today may have new terms tomorrow and you didn't even realize it. What I will tell you is, when we're thinking about linked terms, I always tell my clients, no, the terms that apply to this agreement will be printed out, and they will either not be unilaterally changed, or my customer, the service provider, will get notice of that change and at least have the right to terminate the agreement if they don't like the new obligation, if it's simply too onerous. If you're being asked to adopt customers' guidelines, and again, I will tell you, certainly we have received not only questionnaires from our clients wanting to know what type of privacy practices we have in place, but in some cases making us sign an agreement that says, this is what you're going to do. Well, I know you're small business owners and you're all hungry for business. Don't just sign away your life. Don't just sign away your business. Understand that if you say, I represent and warrant that I'm going to do this, that you are actually going to do it. Because if you don't, and then there's a data breach, you're in breach of your contract. Understanding what law governs the agreement is very important. We've already talked about the legal landscape in California versus New York versus New Jersey. If you sign an agreement that has governing law of California, trust me, you should feel nauseous already. But the fact is, if your client's big enough, you may be saying, yeah, I guess I have to live with this. Make sure you understand what you're living with. As I mentioned, understand the representations that you're giving. And if you can, put in there a disclaimer of all other warranties, express or implied. Now, I will tell you, when you're dealing with individuals as customers versus corporate customers, some states will not allow you to disclaim certain types of reps and warranties as being against public policy. But then what you'll see in documents that I draft is I'll say, to the fullest extent allowed by law, I hereby disclaim blah, 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 blah. If you have an indemnity obligation, understand what you're indemnifying for. So if the agreement says that you will indemnify the customer for a breach of this agreement, that's not limited to third-party claims. You could have also just signed up to indemnify for first party the customer's contractual claims, not just third-party claims because of a breach you did under the agreement. So you want to make sure not only that you engage with an attorney to review the indemnity clause that you're signing up for, but limit it, and if possible, limit it to your negligent acts or omissions, your failure to comply with your stated policies. And so by way of example, one of my clients keeps a lot of confidential information of a number of its customers. And the customers include banks, they include multinational jewelry chains and what have you. I mean, there's a lot of sensitive information that our client collects. And we have
2 minutes.
Of course, I'm always running over time. You know that, Chris. But to understand, we try to negotiate for him, not only that we've told you, Mr. Customer, these are our privacy practices. These are our security practices. You know it. We've disclosed them to you. And if we don't comply with our own stated practices, we accept we are on the hook. But so long as we have abided by our own practices and shit still happens, and it does, then we're not on the hook. Or if we're on the hook, there's a cap on the damages for which we are on the hook. And we also try to include waivers of consequential damages. Because if you don't have a waiver of consequential damages, then the level of damages and the depth of those damages can be significant. And I'll shift gears out of a cyber example just to give a concrete example that was discussed yesterday at a conference I was at, talking about consequential damages in the scenario of a construction contract. So let's suppose that I'm building a building for Chris, and Chris is going to be putting tenants into that building. And Chris has an obligation to make the space available to the tenants in a certain period of time. If I don't deliver the building on time, and I don't have a waiver of consequential damages, not only do I have obligations to Chris just for the fact of my delay, but possibly for the lost rental stream. And depending on how far down we go on the consequential damages, if he was supposed to be getting revenue from his customers as part of their rent, and now they can't generate those revenues to pay him that rent, that could be part of the calculation as well. So try to think about what's in your agreements and how you can potentially pare those down. Now, I know that we are very short on time here, and a lot of the slides that follow here are chock full of information. And because I know we're dealing with the small business owners, I tend to give more information so that you guys can look at these slides after the fact. So I just want to quickly, Chris, do I have a few more minutes?
Yeah, sure. As long as people are on, we can keep the show going.
Okay.
Yeah.
So some of these things we've already talked about in terms of how you could try to negotiate less liability for yourselves, particularly when we're talking about cybersecurity and privacy. But whatever you do agree upon, to the extent that you have subcontractors, try to push those clauses down onto them. And by the way, just as much as your customers may be vetting you, you should be vetting your subcontractors, because the odds are good that your contracts say that you are representing and warranting that you and your subcontractors are complying with these terms, and you are primarily responsible not only for the performance of the services, but breach in those services, including by your subcontractors. If your client has particularly sensitive data, say, you know what, Chris, I'm more than happy to do this work for you. Why don't you give me a company laptop? Make sure it has all the bells and whistles that you want it to have. And then we both know you've got the security measures that you think you need. And that's one way to minimize your potential exposure. Now, granted, not all of your customers are big enough to do that. It never hurts to ask. The worst they can do is say no. Think about also what your obligation is at termination. So Chris has engaged me, and he says at the end of the agreement that I am going to either return or destroy all confidential information. Can I do that? Do I know where it is? And think about this. If you have backup systems, let's suppose that you are responsible and you back up your systems in the cloud. If you have to purge data, if you have to delete it, do you know how to do that from the cloud? And if you don't know the answer to that question before you sign the contract, something you may want to find out about. And again, if you've got your subcontractors also processing data, make sure that they can comply with that obligation. Also make sure that if, God forbid, you're having a fight with your customer, you have the right to keep information that you may need in future litigation. We already talked about what type of notice is required, so I'm not going to belabor this. But I will tell you, again, if the question is whether or not your clients are paying you enough to be your insurance for them, the answer may be don't sign the contract. And as some of you have heard me talk about before, one of my clients who is in the pharma space, pharma marketing, they used to put together conferences for their various customers. And one of their customers, a major pharmaceutical company here in New Jersey, had sent them a contract with 4 pages just on cybersecurity obligations. And my client sent the contract over to me and said, Michelle, could you please interpret this for me? And I waded through the 4 pages. And I basically said to him, it's really simple. You're giving them your firstborn. Oh, and by the way, if you lose the firstborn, you're also giving them the company. And I said to him, quite frankly, you tell me, are they paying you enough for you to be their insurance policy? If the answer is no, maybe you don't enter into that contract. Make educated decisions before you sign on the bottom line to assume unlimited liability in the event of a data breach. And that's what a lot of big companies are trying to get small companies to sign. And by the way, I tell my large companies that ask me to put those in their contracts, do your clients or do your service providers have cyber insurance to stand behind that indemnification? Because otherwise that indemnity may be worth the paper that it's written on, because the number just may be too large. But by the way, you guys don't want money to be out of business. So don't assume risk that you can't deliver on that's going to bankrupt the company. And when you're having these negotiations with your customers, and I know generally we're talking David and Goliath negotiations, say to your customers with a straight face, hey guys, you're paying me $15,000 a year and you're asking me to take on $1 million liability. Let's think about this. This just doesn't make sense. I'll agree to a super cap, maybe 3 times what you pay me in 1 year. Maybe that's not the right number, but try to get your customers to do a reality check. And if they won't, please, please, please think before you sign the contract. In terms of when you're negotiating your own contracts downstream, ask questions, and these are the types of clauses that you want to try to negotiate. I'm not going to belabor this because I know we are very short on time. So we've already talked about this, and I'll breathe now. So, Chris, do we have other questions, comments, thoughts, concerns that have jumped into the chat while I've been doing my last few minutes of speed brain dump?
Let's see if we can do some questions. So I have one that says, what questions should we ask cloud-based software programs, how they keep information safe, and who's ultimately responsible for any data breaches?
So, and actually I saw there was a second question about cloud versus on-premises software.
Yes.
So they kind of tie in together.
Yeah.
Now, I will tell you, and Chris, you know better than I what the next 3 topics are for these lunch and learn programs that we're doing this month for Cyber Risk Month. But I will tell you that I have actually done presentations before, and we may have one coming up later this month on vendor risk management. But that's exactly what this slide speaks to in terms of what you want to try to negotiate with your service providers. Who owns the data at all times? Do you have access to the data at all times? Ask for risk assessments. Ask for SOC 2 type 2 reports. What happens if, God forbid, the provider goes bankrupt? Are you going to be able to still get your information? Do they have an obligation to report a breach to you? And if so, does the time frame within which they're reporting align with the time frame that you have to notify your customers? Are you going to have a service provider stand behind whatever indemnification they give you? Or are they going to say to you the same thing that I just suggested you say to their customers? You're not paying me enough to be your insurance carrier. The answer may be no. But at a minimum, these are the things that you want to ask. And think about the example that I gave earlier of a service provider who was taking care of both Chris and me, and Chris had a data breach. If the cyber limits of a vendor has already been eaten away by prior breaches of the same year, if God forbid you're the next breach for that service provider, there may not be insurance standing behind that indemnification. So I'm not suggesting that cloud is a dirty word, and particularly if you go to a reputable provider, whether it's an Amazon or whether it's a Microsoft or what have you, I mean, fill in the blank, do your due diligence. I will tell you though, and I've negotiated with Square, and I've negotiated Square on behalf of an enormous company. And even for that enormous company that uses Square at its retail locations, we couldn't get Square to take on liability more than an agreed cap, which I assure you was ridiculously low. And our customer accepted the fact that Square was not going to stand behind them more than X dollars. And trust me, the dollar threshold that we agreed to was far lower than it should have been, in my opinion. And our customer knew that they were going to be looking to their own cyber insurance once they went beyond Square. And by the way, if God forbid Square had a breach of their data, the odds are good that Square would have a breach of other folks' data as well. And that insurance policy probably wouldn't be there. And if you guys are using Square, and I'm not suggesting you don't, because I absolutely appreciate the convenience factor, understand Square is not giving you an indemnity. It's just not happening. So by all means, use reputable providers, your providers that are PCI compliant, that are ISO certified and what have you, but understand that they're probably not standing behind you, certainly not contractually. And you may have to sue them, and they have deeper pockets than you do in terms of waging that war.
Awesome. So that is our last question here. We've run out of time, but extremely valuable information. I want to share with everyone what our next event is going to be with you. So it's going to be the part 2 of our Protect Your Tech series, and it's how to identify business assets at risk of a cyber attack. So that's next week, October 14th, I'm sorry, same time, same place. Make sure you get to it. So the link for that is riskofcyberattack.eventbrite.com. And if you need any assistance one-on-one with a business consultant, the NJSBDC has helped over 13,000 small businesses. You can register at njsbdc.com/request-counseling. That's it for us. Michelle, any parting words?
Folks, I just want to thank you so much for joining us this afternoon. I hope you found it value add. If you need more information, if I can provide you further information, please contact me through the SBDC. Stay secure, stay informed, and don't sign the contract that's not worth it.
Thank you so much, Michelle. We'll see everyone next week, and have a nice Friday and weekend.
Stay well, everybody.